Hi, good day to all of you. I am Bijoy P. Pulipura, a practicing corporate lawyer who is specializing in corporate and insolvency laws. Today I would like to discuss with you a specific topic which is actually the basics of the corporate law, which is that is specifically mentioning about the different type of corporate entities. That topic will give you a basic idea about what are the kind of business entities, why we should select one type of entity over the other, what are the advantages over one entity over the other type of entities. See, as you are aware, in India, we can do business in multiple type of business organizations. We will collectively call all these organizations or entities as corporate entities. Primarily, the most predominant or most prominent among the business entities, which is actually that use among all the entities, is proprietorship concerns. Proprietorship concerns are nothing other than entities which are owned by a single person who is actually operating the company without any other registrations under corporate laws. An individual who would like to do a business can start the business in his own name, wherein which he is basically governed by Income Tax Act. Apart from the Income Tax Act, his institution, his organization will also be governed by local laws or the laws in which he is specifically doing business. Example, suppose he is doing business in hospital segment. The law relating to that segment will be applicable to that entity apart from the income tax laws. And that particular entity that individual or the entity will have to abide by the indirect tax laws like GST, Income Tax Acts, on other local laws and the other operational laws. So that is the most predominant or relevant type of business entity in India. And the next type of business entity is partnership firms. We know that the partnership firms are governed by a law called Indian Partnership Act 1932. When two or more persons are joining together to share the business profits and to contribute towards the capital of the company, will be coming under the coverage of a partnership, who are actually coming together to do the business, share the profits as well as losses of the entity based on an agreement. That agreement is called partnership agreement. This partnership agreement, how it is different from the proprietorship is that more than two persons are there, and the maximum number of persons that can be accommodated in a partnership firm is 20. So up to 20 persons that they can comfortably do this kind of entity, choose this kind of entity, wherein the business will continue till the persons are willing to do so. That most of the partnerships in India are actually partnership at will. So whenever they decide to discontinue the business, they can stop the business also. That is one kind, that is an advantage. The similar on the other side of the coin is a disadvantage. The reason is that we know that the partnership firm does not have any existence apart from its members. If the partners cease to be decided to stop the business, or any partners resigns from the business, then actually there is no separate legal entity for the partnerships, and the business will also come to a standstill. So as far as when you are comparing the partnerships with other kind of business entities which we are going to discuss, like companies, this is much lesser in compliances. Compliances are very lesser. At the same time, it's less regulated also. Partnership, as I mentioned, it is regulated by Indian Partnership Act. There is no, though it is a central law, it is actually regulated from the state district registrars. So, like the proprietorship concerns, Income Tax Act, GST Act, sectoral acts, all those will become applicable for the partnership firm also. But here, the peculiarity of the partnership firm is that partners are jointly and severally liable for the acts of the partners. So technically, a partnership is actually giving a threat of unlimited liability to the partners. A partnership is running into losses. The partners' personal assets are also liable to make good those losses. This is in contrast to what the companies are having. So we will see the companies, then we'll come back again to the partnerships after some time. The third type of business entity, which is actually now relevant, is called Limited Liability Partnerships Act. This is under Limited Liability Partnership Act 2008. What is the difference between a partnership firm and a limited liability partnership firm is that in case it's a hybrid version. First of all, it is a hybrid between the partnership and a company. So in case of a company, the company is giving a protection of limited liability to its members. Whereas partnership is not giving that limited liability, the partner's liability or member's liability in a partnership is unlimited. So suppose a partner is actually entering into some kind of business, other partners are also equally exposed to that. So the government had brought in a hybrid version of these two things and made a new concept called limited liability partnership. Right? It's basically meant to be service industry or for the multi-faceted professional entity. Suppose I am an advocate, I would like to enter into a contract with a chartered accountant, a firm with a chartered accountant or a company secretary. Outside India, these kind of the multidisciplinary firms are prevalent. But in India, these kinds of firms are not that much or not legally existing because of the stringent the regulatory body restrictions. Suppose I am as an advocate, I am entering into a partnership agreement with a company secretary or a chartered accountant. If it is a normal partnership firm, I will be liable and responsible for the wrong certifications given by the other professionals because I am not getting the protection of limited liability. If it is a limited liability partnership firm, I have the limited liability protection over the acts of the other parties. So basically, limited liability protection is available in the LLPs. And these kind of entities are now being encouraged to do other kind of business also, not only to the service, even manufacturing or any other kind of business can be in the LLP also, which is more tax efficient and simple in compliances, but at the same time giving the same protection of the companies. So we have seen the proprietorship concerns, partnerships and limited liability partnership. Now we will see the most prominent or the most acceptable form of business entities in India, that is called companies. When we are talking about the companies, we should know that it's all regulated by a central act called the Companies Act 2013. Under the Companies Act, if you divide the companies, you can divide the companies based on several aspects. One is based on the capital requirement, based on the number of members involved. So, if the number of members of a company is between 2 and 200, so minimum number of members is 2 and the maximum number of members is 200, that is an ideal form of organization is private limited companies. If the number of members exceeds 200, then private company cannot accommodate that. So, the nature of the company will be changed to public limited companies. So, if you see that proprietorship concern one individual, partnerships and limited liability partnerships is from 2 to 20. For a limited liability partnership, there are no restrictions to the number of members. You can have even 10,000 or 1 lakh members in the LLP. Where in case of a company which is a private limited company, the maximum number of members is 200, and for a public limited company, it is endless. But there is another classification for the public limited company again. Public limited companies can be classified based on the manner in which it is accepting money from the public. Normally, a private limited company cannot, the basic features of private limited company is that the private limited company cannot transfer shares. Private limited company cannot accept deposits from persons who are not shareholders or directors, or there are certain exclusions mentioned. Only from that persons it can be accepting deposits. And then the public companies. Public company can accept money from the public, but not from a larger public by giving advertisements. If you would like to collect money from the public, either by deposits or by shareholding, you need to get the required compliances done by Securities Exchange Board of India. The companies who are complying with that kind of regulations are called publicly listed companies. So, private companies, public companies which are unlisted, and public companies which are listed in the stock exchanges. So, these are the three type of basic corporate entities. But in the companies itself, there is a variant for a proprietorship concern. We know that in the beginning I have mentioned that for a proprietorship concern, there is no separate law regulating a proprietorship concern. But under the new Companies Act 2013, there is a concept called one-person company, wherein that it is actually featuring all the features of a private limited company, wherein it is a single person can operate it. It's more organized way of doing business. Other type of companies, we know that there are trust or non-profit making entities, which is like NGOs are there. There is an equivalent concept in the Companies Act also, which is called Section 8 companies, which are charitable companies. there are certain separate regulations or rules which is actually governing the governance of the Section 8 company, though it is not a profit-making entity. This is also a type of organization which is actually given power under the Companies Act. Another, we know that there are cooperative societies, farmers' cooperative societies. There is a variant for the cooperative societies also under the Companies Act, which is called producer companies. So these producer companies are actually basically farmers' producer companies, wherein the farmers or the producers will be able to come together into a single platform and do their activities for the common good. So, and apart from that, there are companies called Nidhi companies. Nidhi companies are those companies which are to enable the thrift saving among the members of the company. That means the members of the company can give the deposits to the company and can also take loan from the companies. These all are governed by companies. So these private limited companies or the companies under the Companies Act are regulated by a ministry called Ministry of Corporate Affairs, New Delhi, and it is having a downstream structure like regional directors for different parts of India and then registrar of companies for each state. So the companies, apart from this, if you see the corporate structure, I have mentioned about the basic structure. Apart from this, based on the nature of the entities, there will be separate sectoral regulators. Example, if a non-banking finance companies are called NBFCs. There is a regulator, definitely as it is a company, the regulator will be Ministry of Corporate Affairs. But for an NBFC, the regulator, another regulator will step in who is called Reserve Bank of India. So if you take the insurance companies basically are regulated by the Ministry of Corporate Affairs. For IRDA, Insurance Regulatory Development Authority will be the respective regulator for the particular insurance companies. And these are the basic structure of the company. So if you see the applicability of laws, I have mentioned that if it is a company, Companies Act will be applicable, Partnership Act will be applicable, LLP, that act will be applicable, proprietorship concerns, the Income Tax Act and the other relevant regulations will be applicable. Apart from these three things, if the company or this business entity is setting up their business in a respective field, that respective regulations will also become applicable. If you see, for a company which is into, suppose example, in a company into hospital segment, that hospital or healthcare segment, that company may be formed as a private limited company or it can be a public limited company depending upon the capital or number of members of the company. So for a company, basically that Companies Act will become applicable. Apart from that, being a hospital, that hospital will have separate set of laws, like the HR laws will be applicable and pollution control laws will be applicable and patients service related laws will be applicable, medico legal issues will be there. So for put together, for a company there are multiple laws are applicable which will collectively call it as a corporate law. Depending upon the segment wise whether they are, these provisions will become applicable. So these are the basic understanding about the entities and the applicability of the law. It's a tip of the iceberg, which is actually I have given you only a glimpse of it within a 15 minutes time. And each of these topics are actually worth to discuss in detail and in deep, and that we can do it on another occasion. For the time being, I am stopping now and we will see in another video. Thank you.